Good day, ladies and gentlemen, and welcome to this Morrisons webinar on proving the tenor of a will. This is the third webinar I have given in my field. It demonstrates the ongoing commitment of Morrisons to legal education, the spreading of knowledge, and also hopefully will demonstrate our expertise in this particular field of practice. Proving the tenor of a will. Why do you have to prove the tenor of a will? Well, very basically, the will has been lost in some fashion. How are wills lost? Well, wills can be lost in a number of ways. They can be lost in the post. My firm always sends wills out by registered mail now, where we are asked to do so. And that includes sending wills to the Books of Counsel in Session. A will can be lost when a sole practitioner dies and the Law Society appoints a judicial factor to reallocate ongoing work to other local solicitors. Wills and other documents can be lost when two firms amalgamate. Wills can be lost when a firm moves from one premises to another premises. And wills are also lost when, frankly, a solicitor or his staff are careless. And that's something we should all avoid for reasons which I hope will become apparent during this webinar. What are the mechanics of proving the tenor of a will? Normally, in such a case, the pursuers are the executors named under the missing will, but there is no reason why a beneficiary named therein should not also raise the proceedings. The proceedings require to be served on all individuals named as beneficiaries in the will, and normally also those who would be beneficiaries on intestacy, under Section 2 of the Succession Scotland Act 1964. The pursuer requires to prove three things. Firstly, that the document was executed by the testator. Secondly, the tenor or the actual terms of the will. And thirdly, and most importantly, what is known as the causus omissionis, the reason for the will being missing in the first place. Now, I think it's fair to say that best practice nowadays, and normal practice, is that when you make a will for a client and the will has been signed and completed, you send a copy of the will to the client, where the client has agreed that your firm should hold the will in safe custody for them. And where the client is sent a copy of the will, and we always put a copy of the completed will on our file also, that will normally deal with points 1 and 2, i.e. it will demonstrate that the will was signed and it will clearly show what the will said, i.e. the tenor. Where the action is undefended, the court will normally be prepared to proceed on the basis of affidavit evidence. That's in terms of paragraph 6, 1 of the Actus Adherent Rules of Court of Session Amendment Miscellaneous Order 2009, SSI 2009, number 63, which came into effect on the 23rd of March 2009, but which has also now been extended to Sheriff Court actions in terms of the Courts Reform Scotland Act 2014. The Actus Adherent provides inter alia, and I'm quoting, "In an action of proving the tenor in which no defences have been lodged, evidence shall be given by affidavit unless the court otherwise directs." It would appear that where the action is undefended, the court will be prepared to accept fairly general evidence as to the reasons for the will being missing. And where decree is granted, the extract decree is effectively treated as being equivalent to the original will itself. However, there is a problem here. What happens where the client removes his will from the solicitor's custody and it cannot be found after the death of the testator? This raises a real problem, owing to the legal presumption that where it is clear that the testator had his or her will in their own possession at the time of death, the presumption is that the testator had destroyed the will if it cannot be found, on the basis that they wish to revoke the same, i.e. animo revocandi. The testator in such a case will be deemed to have destroyed the same, and the court will not grant the declaratory action sought. And in that particular case, I would refer you to the case of Clyde v. Clyde, 1958, SC 343. This case was decided in the Outer House by Lord Guthrie. The testator had executed a will in favour of a nephew who was also his business partner. The testator had placed the will in safe custody with his solicitors. But 12 years after signature of the will, it was returned to the testator at his request. He died 7 years after the will had been returned to him. Until his death, he had remained in good terms with his nephew, and he had given no indication whatsoever that he intended to alter the settlement which he had made in favour of the nephew. However, the will could not be found after the testator's death, and he had left no other or subsequent testamentary writings. Lord Guthrie held, applying the dictum of Lord Young in the case of Bondthrone v. Ireland, 1883, 10 Retty, 779, that the facts averred were not sufficient to rebut the presumption that the testator had destroyed his will animo revocandi. The action to prove the tenor of the will was dismissed as irrelevant. As you will probably gather, this was a defended case. The action had been brought against Hugh Clyde and others as heirs and intestacy of the deceased uncle. Hugh Clyde, who was a brother of the deceased, had been confirmed as his executor dative and lodged defences in the action. In his opinion, Lord Guthrie stated, and I'm quoting, "It is settled law that the pursuer in an action of proving the tenor must aver and prove a casus emissionis of the document. But the sufficiency of the casus varies according to the nature and purpose of the writ whose tenor is to be proved. In the case of a testamentary document, the law is set forth in the opinion of the consulted judges in the case of Winchester against Smith, 1863, 1 Macpherson, 685 at page 689. Lord President McNeill and Lord Curryhill and Lord Ardmillan said that the phrase, quote, casus emissionis, unquote, means not only that the writing has actually been destroyed or lost, but that its destruction or loss took place in such a manner as implied no extinction of the right of which it was the evident. They went on to distinguish various classes of cases. Quote, such casus emissionis requires to be supported by much stronger evidence in some cases than in others. For example, if the writing be a disposition of land, of which the tenor is satisfactorily established, and which was followed by enfeoffment and long and interrupted possession, and the instrument or seizing on which it is produced, a comparatively slight proof of the casus emissionis may be sufficient. But if it be such a writing as is usually cancelled or destroyed when it has served its purpose, as, for example, a bill of exchange or promissory note or personal bond, and if it has been destroyed or has been found in the hands of the repositories of grantor actually cancelled, the presumption is that the right of which it had originally been the evident no longer subsists, and very clear evidence is requisite to overcome the presumption. In the case of Bondthrone against Ireland, the daughter of the deceased person, who was his heir at law, averred in defence of an action of proving the tenor of a trust disposition and settlement, which had admittedly been executed, that the deed had been given to her by her father to be destroyed, and that she had destroyed it before his death. After proof, it was held that the explanation of the daughter, which was corroborated, was proved, and that the deed had been destroyed by her on her father's authority and had been validly cancelled. An extreme example of the presumption which I have mentioned can be seen in the case of Bruce's judicial factor against the Lord Advocate, 1969 SC 296. The main problem arising from that case has largely been dealt with by Section 5 of the Succession Scotland Act 2016, which came into effect on 1st November 2016. However, Bruce's judicial factor against the Lord Advocate is a clear example of the presumption being applied. What had happened in that case was that in 1945 the testator had gone to a particular firm of solicitors and had instructed a particular solicitor within that firm to prepare a will. The will was drawn up, signed, and thereafter the testator agreed that it should be held by the solicitors in their safe. In 1949, the same testator went back to the same firm, to the very same solicitor, and instructed a new will which was quite different from the 1945 will. However, on this occasion the testator indicated to the solicitor that he wished to retain all his important documents together at home. A reasonable request, and a number of our clients do that. The will after execution was delivered up to the testator. However, on his death it could not be found. After the testator's death, a dispute arose. The court held that as the testator had held his will, and it could not be found on the testator's death, he had indeed destroyed the will animo revocandi. The interesting point about that case was that as the 1945 will was still in existence, it had not been destroyed, the testator had not given instructions for its destruction. The court also held that, applying the presumption, the 1945 will was revived. The late Professor Meston railed for many years against that decision, saying that it showed Scots law in a bad light. But nonetheless, that was the position up until Section 5 of the 2016 Act, which provided that destruction of a later will would not revive an earlier will which itself had not been destroyed, unless the testator, for example, had given written instructions that the earlier will, which had not been destroyed, should revive. I turn now to the Outer House case of Lauder against Briggs, 1999, Session Cases 453. This was an interesting case because in that case, senior counsel for the pursuer sought to persuade Lord Penrose that there was no such presumption in Scots law regarding deliberate destruction to revoke the will by the testator. And Lord Penrose in the Outer House described the submission by senior counsel as persuasive, but nonetheless said that, being a judge in the Outer House, he could not overturn the previous decisions, which frankly, in my view, were overwhelming. What happened in the Lauder case? Well, in 1978, the deceased had made a will and she left it with her solicitor. However, she moved to England in 1989 and asked her solicitor to send the will on to her. She died in 1995 and the will could not be found. The pursuer averred that after the deceased had taken possession of her will, whilst not being incapax to the extent of being incapable of revoking the same, she had been incapable of managing her affairs and demonstrated, quote, a confused treatment of her belongings, unquote. As Lord Penrose indicated, the pursuer's case was that the absence of a deed from the repositories of a confused person may not, and given the circumstances, sustain the inference that the person must have destroyed the deed at all. Lord Penrose took the view that the averments as to the causes emissionis were sufficiently relevant for him to fix a proof before answer. However, the case was settled before the proof before answer took place. Another important case in this area is McLernan and another against Ash and others. It's an unreported case from the Outer House decided by Lord Ise in March 2001. The case at the relevant time excited some interest as one of the pursuers was Sheriff McLernan. The deceased was his second cousin who had gone into hospital. The action was rare, certainly at the time, as it was undefended, although Morrisons have been involved in a couple of defended cases in recent times. Pardon me. Sheriff McLernan gave evidence that on the day prior to his second cousin going into hospital, she had shown him a holograph will which she had drawn up herself and which she had signed. In terms of that holograph will, she had bequeathed her house and its contents to him and to a father Kilpatrick. He gave evidence that the will also provided that her investment should be divided equally between himself, Father Kilpatrick, and his own sister, a Mrs. Ash. He gave evidence that he had suggested to his second cousin that she should not take the will into hospital with her, because it was well known that personal effects, jewellery and documents could be lost by an individual whilst in hospital. He suggested that she place the will somewhere in her home, which she did, and she told him she had placed it in the cabinet where her crockery was retained, in her living room. Following her death, the will could not be found. However, there had been a break-in in her house, and her belongings had been scattered by those responsible for the break-in. And Lord Easy took the view that the fact that the break-in had occurred, and whilst it might be unusual for a burglar to steal a will, nonetheless he thought that the presumption that the second cousin had destroyed her will herself had been overcome. At paragraph 30 of his opinion, he concluded, and I quote, "It is plainly not sufficient to aver and prove that a testamentary deed executed by a testator and subsequently in his actual custody is no longer extant at his death, if for the only reason that those simple facts alone provide no basis for holding that the absence of the deed is not the result of a decision by the testator to revoke its provisions by destroying the deed itself. There must be averred and proved circumstances which, in the particular case, offer a real possibility that the loss or destruction of the deed occurred otherwise than by destruction by or on behalf of the testator animo revocandi. Where the existence of such circumstances are averred and proved, the decision whether the absence of the testamentary writ is attributable to the possibility or possibilities thus defined, or to the exercise by the testator of his power of revocation by destruction, is one to be arrived at on the balance of probabilities." In England, there is a process for obtaining probate where a will has gone missing, but it seems to me that the English process is more complicated, is more expensive, and in many instances is not successful. My advice to you all is never to lose a client's will, because there could be consequences, expensive consequences. One of the classic examples is the case of Robertson against WhiteCool. This was a case which involved an allegation of professional negligence against the solicitors who had made the will. And the facts which were disputed, and I emphasise that, were briefly that Mr. Robertson had consulted with a firm of solicitors in Arbroath about a dispute in relation to a servitude. Mrs. Robertson, his wife, alleged that at one of the meetings to discuss the disputed servitude, her husband had said to the solicitor in question, "There is another point which is concerning me. I made a will a few years ago. It was a very simple will. It was in favour of my wife. I appointed her as executor. That was all the will said, because we don't have any children." Mrs. Robertson alleged, and I emphasise that this allegation was disputed by the firm in question, that at that point the solicitor got somewhat irate with her husband and said, "Mr. Robertson, we are here to discuss a dispute about a servitude, not a missing will." Mr. Robertson she alleged had explained to the solicitor that he didn't have a copy of the will. He had contacted the solicitors who had prepared the will for him, but to his utter astonishment, when he contacted the solicitors in question, they claimed that not only had they never made a will for him, he had never been a client of their firm. The inevitable happened. No will was put in place. Mrs. Robertson alleged that a solicitor of ordinary competence, following Hunter v. Hanley, 1955, should at that point have said, "Mr. Robertson, this is a serious matter. We need to put a new will in place for you as soon as possible." The solicitors denied that the conversation in question had ever taken place. Mr. Robertson died. There was no copy of the will which could be proved, and his estate was intestate. And as it happened, his wife's prior rights and legal rights did not exhaust the whole estate, and the remainder of his free estate fell to beneficiaries with whom Mrs. Robertson did not get on. She sued the solicitors for professional negligence. The case was appealed to the Outer House. It did not go to a proof before answer or proof. It was settled. When I was speaking at a conference a few years ago, I mentioned the Robertson against Watt case, and a lady solicitor approached me at a suitable break in the proceedings and said, "Mr. Kerrigan, I was involved in that case. I was involved in the aftermath of that case," i.e. she was not from one of the firms who were either being sued or who had been alleged to have made the will. And she told me that after the case had settled, some time after the case had settled, the firm who had denied that Mr. Robertson had ever been a client found his will. And she indicated to me that there were consequences for that firm. I would imagine financial and reputational consequences. Is a solicitor liable if he loses a client's will? I was asked to give an opinion a couple of years ago in circumstances where the testator had used the same firm of solicitors for a number of years, and they had made a will for her. And they wrote out to her after the will had been signed, saying, "Here is a copy of your will as signed by you. The principal document has been placed into our safe in safe custody for you." However, the testator fell out with her solicitors and removed her will, or that was what was alleged by the solicitors in question. When she died, she had appointed a friend as her executor. The friend found the copy will in her friend's possessions, and also the letter from the firm of solicitors who had made the will, which quite clearly stated, "Here is a copy of your will, we are holding the principal." She went to see the solicitors in question and asked for the will. She made it clear that she was aware that her friend, now dead, had fallen out with them, and they would therefore not be instructed in the winding up of the estate. However, the solicitors, having checked their records, came back to her and said, "We don't hold this will." She therefore raised an action to prove the tenor. Now, as I understand it, one of the partners in the firm in question gave an affidavit, in terms of which he stated that he had some recollection that the lady in question had turned up and very angrily demanded return of all her papers. Because she was creating a bit of a rumpus in reception, the solicitor had a recollection that he may have instructed a member of staff just to give her all her papers back. However, they did not keep a record of that. They did not ask for a receipt. It was simply his recollection. As I understand it, when the case, which I think was heard in the Court of Session, was being examined by the Lord Ordinary, he discounted the affidavit. He said, "The recollection may not be correct. It has not displaced the presumption that the lady destroyed her will animo revocandi," and he granted the application. The executor, who found that the costs of the application were something like £15,000, then wished to sue the solicitors who she claimed had lost the will. to recover the costs of proving the tenor. I was asked to give an opinion on whether prima facie the solicitors might be liable. I referred to McBride in the Law of Contract in Scotland, 2nd edition, paragraph 9, period 5.3, which states, and I quote, "Under a contract of custody for hire, locatio custodiae, goods are placed in another's possession and rent is paid for the custody. Custody can also be an element in a contract for services, locatio operis faciendi, as when a car is left in a garage for repair. Deposit is a contract by which one delivers property to another to be kept for the owner without reward. The question from time to time has been raised as to whether the standard of care required of the keeper differs according to whether the contract is gratuitous or onerous," unquote. Pardon me. McBride concluded that the standard of care was the same whether the contract was gratuitous or onerous. That was the opinion I gave to the solicitors in question. I did make it clear that they would require to consider whether or not the loss in question was one which an executor could recover, but in the face of it, it appeared that there had been negligence on the part of the solicitors who had prepared the will and had apparently lost the same. My advice to anyone is that in dealing with matters of this nature, if a client asks for return of their will, obtain a receipt from the client. If the client asks you by telephone to send their will to a bank or to another concern, which is then going to hold the will in safe custody, ask for instructions in writing. And when sending the will out to a third party, as so instructed, get a receipt from them. Because if you don't, then you may face a claim if the will cannot be found after death and an action of proving the tenor is raised. That's all, ladies and gentlemen. I hope you found that to be interesting. I will be giving another webinar on rectification of a will in a few weeks' time. Thank you.